So I want to now turn it over to our managing partner over at the Orlando office. I got to get my offices straight here. Orlando, Florida. We have offices throughout the state. Alan Schwartzseid, our instructor for today for navigating the Federal Fair Housing Act assistance animal or pet. Take it away, sir.
All right. Thank you, Jeff. So my name is Alan Schwartzseid. I am the managing partner, like Jeff said, for the Orlando office of our firm. K. Bender Rembaum has offices here in Orlando. I'm right next to UCF. Also in Pompano Beach, Palm Beach, and Tampa and Miami by appointment. We do practice statewide. So if your community needs help, this is one of very few plugs that we'll actually make. The goal here is education, not clients. But if you need help with any community association related issue that may come up in your community, this is literally all we've done. It's all we've done for 30 years, 22 attorneys, all practicing in this particular area of law. 8 are board certified in this area of law, 1 board certified in construction. So we're able to keep that type of issue in-house for the most part. But bottom line, we've got an hour and a half long class and an hour to present it. So I'm going to go ahead and get started. There are a bunch of case studies at the end of the slides. Jeff mentioned that you will have access to those slides, presuming you stick around and fill out the survey at the end of the class today. So you're welcome to take a look at those. If you've got any questions about literally anything we discussed today or any other issue pertaining to a community association, my email address is right on the slides. Right. Come on, clicker. No, I guess not. Right around, it's not happening. All right. as@kbrlegal.com. So moving forward, I just wanted to clarify all of that. We're happy to present this for your education, and I'll look forward to getting the questions towards the end. So moving on, policies and enforcement. So the policy of the United States is to try and provide fair housing for everyone in the country. Mentioning policies, the first thing that I'm going to mention substantively here, every association can and should have its own written policy that's prepared by counsel, identifying how you're going to deal with requests that we're going to discuss today by disabled or handicapped people for accommodations to your rules or modifications to the common areas, common elements, whatever you want to call them. That is item number 1 that I think is absolutely crucial, because the response to any complaint for fair housing includes whether or not, and this is a form response that's required, the information that these entities, these governmental entities are going to request includes, do you have a policy for avoiding violations of the Fair Housing Act or the Americans with Disabilities Act? If your answer is no, that's not fatal to your defense, but it certainly looks better if you say we have a policy, it was prepared by counsel, we followed it in this instance, and we don't think that the owner is entitled to the accommodation or whatever they're asking for. There are a bunch of other policies I think you should, every community association should have. Feel welcome to reach out to me if you'd like to discuss those. I'm not looking to take your time here, but I do think that it's crucial that there are 4 other policies that every community should have. But moving on within the context of what we're talking about today, the Fair Housing Act. What is this? It's basically a law that is set out by the legislatures nationwide, and there's also a state and local version of this. But it basically says you can't prohibit discrimination in housing on the basis of race, color, religion, sex, national origin, familiar status, which is basically age, or disability. Now, again, Florida law has the same thing, and there are also local ordinances. For example, Palm Beach County Code, that municipal code says that discrimination is not allowed on the basis of sexual orientation, age, marital status, or gender identity or expression. Keep in mind, none of these things are in the federal law. That doesn't mean you're not violating local or state level laws by doing these things. So for example, in Orlando, Chapter 57 of the Orlando Municipal Code mirrors the Fair Housing Act and does include sexual orientation and marital status. Now, when someone claims that they had their rights violated regarding the Fair Housing Act, it's 1 year to file in Florida since the last act of discrimination, meaning you said you're not allowed to have this service animal or this emotional support animal because we think it's a bogus claim that you even need it. Okay. That individual has 1 year from the date that you denied that animal and that accommodation to file a lawsuit or file a fair housing claim against the association. If they're filing in federal court, they have 2 years. Now, there may be other claims that these are the ones that are most specific to this issue. As a practical matter, just understand that as soon as you say no and they find out that 1 year has passed, they're going to send another request for the accommodation, and then that timeline starts all over. So just understand, don't think that you're getting out of a situation by letting it ride for a year or two. You might be, but it's very easy for the owner or the person requesting the accommodation, because keep in mind, it doesn't have to be an owner. It's anyone that wants to use the property for the most part. They're going to be able to kind of reincorporate that claim and revive it. So there is a difference between these two codes. You don't care about them, so I'm not going to go through them in detail, but just understand these are federal level codes that are similar to the Florida statutes. They're just at the federal level, the nationwide level. And they authorize the creation, funding, and operation of codes and committees, just like your declaration would, but this pertains to specifically fair housing issues. We've got some notes here about what is included in the Fair Housing Act. Just understand, you'll have these slides. I'm not going to go through them in detail because, frankly, going through them at this speed is the only way we're going to get through everything. So what does the Fair Housing Act actually say? What does it say you're not allowed to do, more importantly? You can't, as a housing provider, which includes an association, can't discriminate against housing applicants or residents because of a disability or the disability of anyone associated with them. Can't treat people with disabilities less favorably than others. It also is unlawful to refuse to permit at the expense of the disabled person reasonable modifications of existing premises, meaning you might have to actually change what is in your community, the appearance of the community, change the, you might have to add handicapped access ramps if you didn't have that because at the time that you built your building, code didn't require it, etc. These are things that an owner can ask for, and the important part here is you have to allow it when it serves a disabled person's disability, but they have to pay the cost of those modifications for the most part. And it's going to be something that allows the person the full enjoyment of the premises. So what do we mean by this? It's not you have to be nicer to people with disabilities. Don't sit here thinking, well, you'll excuse me, but kiss their butts. We don't. We have to provide an accommodation that gives them the same right to use your facilities. And sometimes that it includes allowing them to do things that everyone else in the community isn't allowed to do. So essentially, you're allowing them to make reasonable accommodations to violate your rules so that they have full use of your community, full use of their lot, full access, and the opportunity to enjoy a dwelling, just like someone who doesn't suffer that disability. That is all we are saying under the Fair Housing Act, is that everyone should have an equal right and ability to use your property. There are exemptions from the Fair Housing Act, meaning that you don't have to allow those accommodations or modifications in certain circumstances. So the FFHA doesn't prohibit a religious organization from limiting sales, rentals, occupancy of dwellings it owns or operates to someone of the same religion, or from giving preference to those people unless, so this exception does not apply if membership in the religion is restricted by race, color, or national origin, or the dwelling has a commercial purpose, meaning it's a not-for-profit institution. Okay, private clubs also don't have to comply with this unless the lodging is not, if the lodging isn't open to the public. And this is where, I'm sorry, let me step back. A club that provides lodging, meaning that you have, let's say, a country club that also rents hotel suites within the club property. Okay. If that lodging is not open to the public, meaning it's only to be used by the members or their guests, if the lodging is incident to the club's primary purpose, this is a tennis and golf club that happens to have hotel rooms, or the lodging is not for a commercial purpose, okay? All of these things need to be in place in order for a private club to not be subject to fair housing requirements. Familial status, the FHA doesn't apply to discrimination for housing for older persons, which is 55 and up or 62 and up communities. So that is not discrimination as long as you're complying with the requirements of those laws. Controlled substances, the fact that you are convicted of the illegal manufacture distribution of a controlled substance doesn't give you special rights. It's for disabilities. And then real estate, it doesn't apply to certain real estate transactions where the owner doesn't have an interest in more than 3 single-family houses at any one time, and the house is sold or rented without the use of any real estate broker, agent, or salesperson, or the facilities of any person in the business of selling or renting dwellings. Okay, that's an oversimplification. What does this mean for practical purposes? If you're selling your property by yourself, you don't have to provide reasonable accommodations or modifications to someone who's coming to buy the property or look at the property. That's number 5 in a nutshell. Now, there are 2 acts that we're talking about today. One is the Fair Housing Act. One's the Americans with Disabilities Act. I can tell you 99.9% of the time, if you're in an HOA, the ADA does not apply to your community. In a condo, it might. But keep in mind, these laws are substantially similar, meaning that it really might not even matter that the ADA doesn't apply until there is a claim filed and it reaches your attorney. Now, again, when I say it reaches your attorney, what I mean is you've already gone through the process that your attorney has put in a written policy, and you're not sure if you should, after all of that is done, deny the request. Okay, that's when you should be involving your attorney, because if not, it might be at the stage where a HUD or fair housing complaint has already been filed against the association. That's where it's going to matter whether we're talking about FHA or ADA. Let's see. Moving on. Handicap and disability, for purposes of what we're talking about here, pretty much mean the same thing. It's just which law that term is coming from, the ADA versus the FHA. The definitions are pretty much identical. So there's really no reason that you should be distinguishing between someone who says they have a handicap versus someone they have a disability. And by the way, anyone who says they have anything that would qualify as a handicap or disability has already told you enough that you should be implicating and thinking about these fair housing and ADA issues. So what is a handicap? What does that even mean? What is a disability? Because keep in mind, someone not being able to do everything that they want to do isn't necessarily a handicap or disability. I'm dealing with one right now where, frankly, someone just didn't feel like driving 2 hours because they were elderly to go to a meeting. I can't give more information than that because it's an ongoing issue. But to me, just because you don't want to drive doesn't mean you're incapable of driving due to a disability. And so from my perspective, that would be a baseless argument of a need for an accommodation. You might want it, but you don't need it. And whether you need it depends whether you have a handicap or a disability that is actually served by that accommodation. So it's needing it in order to use the facilities and use the community and participate in community events like anyone else would that doesn't suffer that handicap or disability. So let's get back to the definition here. What is a handicap? It's a physical or mental impairment which substantially limits one or more major life activities. Having a record of that type of impairment, meaning there's a doctor's note in the file, so to speak, or being regarded as having such an impairment. In other words, you can visibly tell this person has this disability or handicap. Handicap doesn't include current illegal use of or addiction to a controlled substance, like we said a minute ago. So being a drug addict is not a handicap, even though it does impact major life functions. Physical or mental impairment. What does this particular term mean? It's a physiological disorder or condition, or any of these other things that are described here. Basically, a problem with your physical system, so to speak. Or a mental impairment is a mental or psychological disorder, and that could be some form of, you'll excuse me, but psychosis. It could be a heart defect, heart disease, diabetes, cancer, literally anything that impacts your ability to perform major life activities. Okay, I'm not going to go through the list because frankly, we just don't have the time. But again, once you fill out the survey, you'll have the ability, like Jeff mentioned, to pull up the slides and have them accessible going forward. And if you're working with us, then frankly, my suggestion is that you have the attorney that you're working with go ahead and prepare that written policy that's going to outline a lot of this stuff if you don't already have one. If you're not working with an attorney or you're not happy with your attorney, I'm happy to talk to you about preparing these for you. Getting back to the slides, major life activities. What does that mean? Okay, it's caring for yourself, performing manual tasks, walking, seeing, hearing, speaking, breathing, learning, and working. Major life activities. Okay, we're not talking about your ability to pick up a pencil. Okay, if you can do something else that's replaces picking up that pencil, that is not a major life activity that you're losing out on. It may be from your perspective because you're an artist and you've lost the ability to perform your art. But from a fair housing perspective, that is not a major life activity that you suffer a disability, which causes you to be impaired and unable to perform. Now, getting into having a record of the impairment, this is where we talk about a history or a record or classified as having. This does not mean that you have self-identified as a disabled person. Okay, it means that self-identification might lead to further inquiry where we'll get into, okay, well, we can't tell what disability you allege you have. Do you have a doctor's note that says you suffer a disability that this reasonable accommodation would serve, etc. Now, regarding as having an impairment, has a physical or mental impairment that doesn't substantially limit one or more major life activities, but is treated by another person as constituting that type of limitation, meaning you don't actually have to have a substantial impairment if someone, your doctor, says that it is a limitation on your ability to perform those activities. You have a physical or mental impairment that substantially does limit one or more major life activities only because of the attitudes of others towards the impairment. In other words, other people think that you're impaired and they treat you differently as a result, or doesn't have any impairments, but treated by another person as having the impairment. So in other words, this is the subjective component to a large extent. Unlawful inquiries. So you're limited in what you can actually ask. The association can't ask if someone has a disability, if they haven't brought the issue up. Okay, so wait until they mention it is what we're saying. Don't offer up an accommodation or demand information that's only relevant to an accommodation that someone hasn't actually requested yet. You can't just say, well, you're considering moving in to our community. Do you have any disabilities that we need to know about? Take that off your application and frankly, send your application to a qualified attorney to review if that's in there. If a person intending to reside in a dwelling, you can't ask if they or anyone associated with them has a disability. Again, same concept. And you also can't ask about the nature or severity of a disability other than saying, do you have a doctor's note that says this is a necessity? Now, we get into the actual accommodations and modifications. So a reasonable accommodation is literally someone wants to break the rules. They have to do that in order to have full use of the premises or full use of the association's amenities. That's going to be allowed under the Fair Housing Act. So this is a reasonable accommodation. And frankly, from my perspective, it doesn't actually have to be reasonable. That's just a legal term. So it's an accommodation of the association's rules, regulations, policies, covenants, etc., to accommodate a disability. A reasonable modification is what we talked about earlier, where you're physically changing the configuration of parts of the community to accommodate a disability. These are different concepts, but they're treated very similarly and evaluated very similarly. Someone with a disability may need one, the other, or both to have an equal opportunity to use and enjoy the dwelling, meaning their unit, their lot, etc., including public and common use spaces, so your common areas and common elements. So what we're saying here, just to recap, is a reasonable accommodation is allowing someone to violate your rules to serve a disability. A reasonable modification is making a change to your structural components, and I don't mean structural as in you're tearing out windows, but you're making changes to the building so that this person has the same ability as everyone else that doesn't suffer their disability to use the property. Okay, basically saying no to a request for a reasonable accommodation that's actually necessary is against the Fair Housing Act and can subject the association to damages. Frankly, here's the other concern that I haven't mentioned yet. It can subject individuals to damages. Okay, the complaints that I've dealt with in the last few weeks have involved owners who were basically raising these claims against every director, every officer, every manager, and the association and the management company for alleged violations of these laws. So don't think that you get off scot-free. You may be covered by insurance, but I'm finding more and more that even directors and officers' liability insurance policies don't cover these claims, and you end up with your attorney having to defend them on behalf of the association and the directors. So just be careful that you are aware you're personally putting yourself at risk by rejecting these requests improperly or even perceptibly improperly. As to assistance animals, which is what we're really here to talk about today, requests are made for reasonable accommodation to the pet restrictions so that a disabled person may have an assistance animal within the community. Let me clarify. If you don't have any pet restrictions at all or animal restrictions at all, you're saying yes every time someone asks for this because you have no basis to reject the request. Not only might it be something that you're required to allow under the Fair Housing Act, it's something you can't decline or reject or deny under your own governing documents. So just be careful. When I say you might have an obligation to allow this, if you don't have pet restrictions in your documents, you have to allow it no matter what, whether this person needs an accommodation or not. You're not actually allowing an accommodation in that circumstance. You're just complying with your own regulations. If you want to insert those regulations, you would need an amendment, and then you would need to comply with reasonable accommodation requests. So again, for assistance animals, the procedure should be in place and very clear and in writing. But understand, you can put the procedures in place for the association, unlike all of the other regulations that you're going to put in place for your association. These are not for the owners to have to comply. It might be a package that you put together that makes it easier for the board and quicker for the board to review these things when these requests come in, but it's only going to be something that is suggested, not required, because there is zero requirement whatsoever under Florida or federal law that an owner requesting one of these accommodations actually puts it on a specific form. The association can adopt those forms, can adopt the procedures, but the procedure is going to be we request, not we require, that anyone that wants an accommodation fill out this paperwork. It just makes it easier for us to review, and we'll be able to get you an answer quicker. Just understand your policy is going to be separate from that paperwork. Your policy that I suggest putting in place is a step-by-step guidebook for what to do when you receive these requests. Now, some of it's going to be in the slides today, so you're welcome to share those with your board, but I would suggest that it be in a clear writing that is adopted explicitly by the board and prepared by counsel. So getting back to the procedures, the FHA doesn't require the association to adopt any formal procedures. That doesn't mean that I don't recommend doing it. And in fact, I strongly recommend that the association have written procedures for this. One, because it can aid the disabled person in making the request. And two, it shows that the request received proper consideration if there is a dispute later on where someone says they didn't respond in time, or they didn't acknowledge and agree to my request, and I think that they did wrong. If the board follows these procedures that are established by counsel and prepared properly, you're pretty much safe when it comes to these requests. The association can, by the way, make the truth and accuracy of information provided in the process part of the representations made by a tenant under a lease to the extent the lease requires truth and accuracy. In other words, you can say that if you lie about needing a service animal in your application, then your lease can be deemed denied after the fact, and you can be evicted because you lied on that form. You can't refuse a request because the individual making the request didn't follow those procedures that I'm talking about. This is why I say it is a helpful tool for the member or the individual who's requesting the accommodation. It's not going to be something that you absolutely require before you'll even consider that type of application. Just understand when we talk about truthfulness, there is a statute. I'll give it to you right now. It's not in the slides. Florida statute section 413.08 sub 9 says that it is a second-degree misdemeanor to knowingly and willfully misrepresent that you're using a service animal, qualified to use a service animal, or are a trainer of a service animal. Okay, so that's basically 30 hours of community service to be completed in not more than 60 months. So second-degree misdemeanor, according to section 413.08 sub 9, if you lie about these service animals being actually qualified or necessary. I found that a helpful tool, not to point out to the requesters, but to put in the policy that there might be a report by the association if it's found that they're lying on those applications. So the request: a disabled person is not entitled to receive an accommodation unless they actually ask for one. Okay, don't sit there thinking, oh, well, they've got a dog and I know they're disabled, so let me go ahead and send them a letter or an email saying, hey, do you want to keep that dog? Because it technically violates the rules, but we think that you need an accommodation. No, you send your violation letter out if they haven't requested the accommodation. And when they respond saying this is a service animal, this is an assistance animal, your response is, oh, okay. Then you go through your procedure. The request doesn't have to be made in a particular manner or at a particular time. In fact, the request can be made after someone moves in with this animal. So don't think that just because they moved in first and then requested the accommodation, or didn't request the accommodation and requested it after you sent the violation letter out, like I just described, that is going to alleviate the association's responsibility to actually comply with that request. It has no impact as to when that request is made. It's just that it was made. The request can be made on behalf of someone else. Doesn't mean that that other person that is making the request had to make it because the person suffering a disability wasn't able to. I could send a request on behalf of John Smith. Doesn't matter. Okay. It doesn't matter whether John Smith's disability is that he's an amputee or that he's got brain damage and can't get out of his bed. That makes no difference when it comes to who can request and how they can request a reasonable accommodation. And also, you don't need to mention the words reasonable accommodation or FHA. That's going to be helpful, but anything that could reasonably be interpreted as a request for an accommodation must be treated like one. Okay, so you're going to go through this process. Anytime someone says, I have a disability, or anything approaching, I have a disability, and this is a support animal, service animal, assistance animal, or I need the animal to help with my disability. As soon as you hear one of those two words, you're starting this process that I'm recommending you have in writing for your community. Requests can be made even after the resident brought the animal in, which I apologize, I already mentioned that. What type of animal is it? That's going to make a big difference. Is this a service animal or is it a support animal? There's HUD guidance from 2020 that I'd suggest you look for. And if you literally search HUD guidance on assistance animals, I think that's the topic, the title of this document. It's extremely helpful. And it will go through this analysis step by step with examples, etc., in a lot more detail than I can provide within an hour-long course. But once you receive the request, the association needs to ask itself, meaning the board sits and tries to decide, is this a service animal or a support animal? Because there are big distinctions between one and the other. A service animal is only under the ADA. It doesn't exist under the Fair Housing Act. And it's narrowly defined as a dog, not any other animal, that is individually trained to do or perform tasks for the benefit of the individual with the disability. Okay. Now, this is specifically the dog serves a specific purpose and is trained for that purpose. If the animal is not a dog or the animal is not trained for a specific function that serves the disability, they're not a service animal. That doesn't mean they're not a support animal. So you're not done with the analysis. Okay, performing work or tasks mean that they're trained to assist with the disability. Other species are not service animals, but again, might be support animals. And the tasks must be directly related to the disability. Okay, the emotional support, comfort, well-being, and companionship, none of those are work or tasks. This is a dog that presses a button that says this person is having a seizure and they need help. It's a dog that's able to go get something if the individual's having an issue. It's a dog that serves a specific task. So again, is it a dog? If the answer is yes, move on. If the answer is no, it's not a service animal, you end this line of inquiry and move on to, is it another type of assistance animal? So this slide should be very helpful when you're starting your analysis of, should we allow this or not? Are we required to allow this or not? Moving forward, is it readily apparent that the dog is trained to do work or perform tasks for the benefit of an individual with a disability? If the answer is yes, it's a service animal and you're done. You have to allow it. If the answer is no, it's not readily apparent, then you keep moving forward. Okay, readily apparent for this purpose, we've put it in here: guiding someone who's blind, pulling a wheelchair, providing assistance with stability or balance with someone who is wobbly, so to speak. And I don't say that lightly. That includes my grandfather, who's a great man, but happens to suffer from that. If he had had a service animal in his building, they would have an obligation to allow it if he requested it, because he is a wobbly gentleman. Moving forward, is the animal required because of a disability? If the answer is yes, and the work or task is actually identified, you need to grant the request if it's otherwise reasonable, because the animal is a service animal. If the answer is no, the animal's not a service animal, but you move on to the next line of inquiry as to support animals. Okay, if at least one action of the dog, and again, service animal is only a dog, is trained to take, is helpful to the disability, the dog should be considered a service animal. If no specific action is identified, the dog should not be considered a service animal, but maybe another type of assistance animal. Now, I've said all along, only a dog is a service animal. I believe, and don't quote me on this, that I've heard that a miniature horse can also somehow be a service animal. So just understand, that might be something to run by your counsel. If I'm your attorney, run it by me before you deny that, just because it's not a dog. Now, it's not a cat, it's not a pigeon. There's no such thing as a service pigeon in this capacity. But if it's specifically a miniature horse, I'd run it by your counsel before simply rejecting it. If it's not a service animal, like I said, it might still be a support animal. Those are trained or untrained. It doesn't matter what kind of animal it is. It can be pretty much even barnyard animals, monkeys, kangaroos. I've had emotional support ponies in condos that went up and down the elevator. I mean, that is something that might be required, as silly as it sounds. These are the types of things that we see in practice. And you know what? That was one that I've seen that I told the association you should be allowing it based on the application or the request that was made and based on the information that we have. So when it comes to we're moving on from service animals now to support animals. Establishing a disability. Does this person have an observable disability? Meaning, is this open or obvious? Or does the association already have information that gives reason to believe that person is disabled? If the answer is yes, we keep going. Okay, proceed to establishing that need. Now you've already said they have a disability. The next component of determining whether to allow a support animal is, does the animal actually provide something that meets that need? If that person has anxiety, does that animal allegedly help with the anxiety, etc.? If the person doesn't have, if the association has no reason to believe the person suffers a disability, we move on to the next question in establishing the disability. Observable disabilities: blindness, low vision, deafness, being hard of hearing, mobility limitations, other impairments, neurological impairments, mental illness, and other diseases or conditions that again affect major life activities or bodily functions. So these are all of the things that might cause the association to have an obligation to move forward in this process and not just reject the request outright. Moving on, has the person actually requested an accommodation? And if so, have they provided information that reasonably supports that they have a disability? If the answer is yes, they've provided some kind of doctor's note. And I say doctors, I mean physician. So don't think it has to be a doctor. It can be any treating physician that has the ability to know what disability this individual might suffer. If the answer is yes, they've provided that information. Oh, sure, now the pointer works. Then you proceed to the establishing the disability-related need. Now, that's not establishing the disability. Establishing the need is a separate concept, part of the same process. Okay, if they haven't provided the information, the association doesn't have to grant the accommodation, but you should be requesting the documentation. Okay, the association must provide the person requesting the accommodation with a reasonable opportunity to provide information that reasonably supports that the person has a disability. If you request the documentation and their response is, go screw yourself, I don't have to give you anything, and they don't have a readily apparent disability, your response can be, thank you, but until you provide that, we can't move forward in this process, and your request is respectfully denied. We'll reopen the line of inquiry if and when you provide the documentation that we need to verify whether you actually suffer a disability. Moving along. Information about that disability might include a determination of disability from some kind of government agency, receipt of disability benefits, so Social Security income, Medicare, supplemental security income for a person under 65, veterans disability benefits, etc. Eligibility for housing assistance or a housing voucher received specifically because of a disability. Information confirming disability from a healthcare professional. This is what I was talking about a moment ago. But keep in mind, when I say a physician, that's any of these people on this list or any of the people I listed before that on this slide that can provide this information to the association, or that the owner or individual who's requesting the accommodation can provide to the association and still be entitled to this, potentially entitled, excuse me, to this accommodation. And a determination that someone doesn't qualify as having a disability for purposes of a specific benefit or program doesn't necessarily mean they don't have a disability for purposes of the FHA or ADA. So the fact that they've been rejected, for example, for disability from federal, state, or local government agencies doesn't mean they don't still have a disability. That may just mean that they're still able to function in certain capacities, but because of this disability, they don't have the ability to equally enjoy your particular community, their lot or unit within your community, etc. Okay, they may still be able to work, which means they're not getting certain disability benefits, but they still need the accommodation. So that doesn't mean just because they were denied federal, state, or local government agency disability benefits or any of the others on this list doesn't mean that your inquiry is done and they're not entitled to a reasonable accommodation. Here's just a list of impairments that will almost always be found to impose a substantial limitation on a major life activity, resulting in a determination of a disability. In other words, if this person suffers any of these things, they will almost always be entitled to meet the disability requirement of having an emotional support animal or an assistance animal. Establishing the need is the next step in this assistance animal debacle. Okay, has the person requested the accommodation provided information that reasonably supports that the animal in particular does work, performs tasks, provides assistance, or provides therapeutic emotional support? That's the one where it gets a little sticky with respect to the individual's disability. If the answer is yes, you proceed to the type of animal as the next line of inquiry. If the answer is no, that person has not documented in any way, shape, or form, and it's not in any way, shape, or form obvious as to how that animal actually assists with the disability, you're done. You don't have to allow the accommodation. Now, keep in mind, this is after asking for that documentation. It's not just, well, you didn't provide me the documentation with your initial request, so I'm rejecting your request. Just understand that's very important. The association needs to provide a reasonable opportunity to provide information that reasonably supports that the animal does these things and serves the disability. So it's not just, again, your application didn't include it, we're done, you're not getting your ESA. It's your application didn't include this information. We can't tell just by looking at the animal what purpose it serves towards your disability. We're going to need a little bit more information in order to grant your request. Documentation, again, we've got physicians and others General to the condition, meaning you're not asking for specifics regarding the condition. You're not saying how severe is this condition. You're not saying, well, it's a disability related to mobility. What is their leg broken? What's the deal? You're not getting into those specifics. If a physician or any of these individuals says that there's a disability pertaining to mobility, that's good enough. But you do require specifics as to the individual who is entitled to it. In other words, that individual is named in the letter, and the animal is named in the letter, and the function that the animal serves is named in the letter. It's not just they serve a disability. That's not good enough to me. Okay, it's they serve a disability pertaining to mobility or pertaining to anxiety in this very generic manner. They provide assistance with emotional support to serve and defray or defer or deter or reduce the anxiety that this individual suffers. That's what we're looking for. Relationship or connection between the disability and the need must be provided. And we talked about that, especially where you can't just see that on your own. For non-observable disabilities and animals that provide emotional support, you can ask for information necessary to conduct an individualized assessment of whether you must provide the accommodation. The lack of that documentation may be grounds for denying the request. And HUD encourages housing providers to direct requesters to the guidance that I talked about earlier. Here is the actual name of the document from 2020 to help the requester understand what information is being asked for and ensure that you get the information you need, and more importantly, from the association's perspective, to make sure that you're actually complying with these guidelines and not getting in trouble with the Florida Commission on Human Relations or any state or federal courts. We do know that there are websites that sell certificates, registrations, licensing documents to anyone who can answer questions and pay a fee. We've already talked about the criminal prosecution that could occur as a result of this. In HUD's experience, and this is coming directly from HUD guidance, that documentation isn't by itself sufficient to reliably establish that an individual has a non-observable disability. So in other words, if you know that this documentation is internet-based and there was no licensed healthcare professional who actually provided the services, and it was just a fill out some information, get your certificate, no inspection or interview needed, you can question the reliability of that document. You won't reject the individual, but you'll say, was there any kind of investigation? Can we contact, well, let that one go because that's a no-no. One reliable form of documentation is a note from a healthcare professional that helps that person particularly, that confirms the disability or need for an animal when the provider has personal knowledge of the individual. That is specifically helpful. Keep in mind, all these requests go into the association's official records, but none of them, all these documents are not subject to inspection when someone is requesting to inspect your official records of the association. So keep in mind, social security numbers, medical records, which is every one of these pieces of paper that says, I need an accommodation, here's my doctor's note, here's this, here's that. Any of these records are most likely not subject to a records inspection request. If you get the request, what you should be doing is saying this was allowed pursuant to a request for an accommodation of the association's rules, something of that nature. If someone questions why this exception was allowed. Okay, the type of animal is the next issue. Listen, if it's a dog, you're probably fine. If it's a cat, you're probably fine. If it's a Bengal tiger, let's go a little forward into this. Is the animal commonly kept in households? If the answer is yes, request is granted unless there's an exception. If the answer is no, it's not an animal that's commonly kept in households, the association is not required to grant the accommodation except in rare circumstances, meaning you might still be required to allow it, even if it's some crazy kind of animal like a pony sitting in a condo. If they're requesting a unique animal, then they have a substantial burden of demonstrating that that particular type or that particular animal is the only thing that will serve the disability, or that it specially serves the disability. And the individual who's making the request is encouraged to submit documentation from a healthcare professional confirming the need for this particular animal or this particular type of animal. So some examples, well, I can't use a dog, I can't use a cat because I'm allergic to both. That type of emotional support animal won't help me because frankly, even if it alleviates some anxiety, it'll create more because I'm going to start sneezing and coughing all over my unit. Without the animal, the symptoms or effect of the person's disability will be significantly increased. So a trained monkey performs tasks. The monkey's been trained to retrieve a bottle of water from the refrigerator. It is a monkey, not a dog, so it's not a service animal. That is still an assistance animal that the association is going to have to require because the monkey can use its hands to perform manual tasks that a dog couldn't or a cat couldn't. So it would be based on a specific need for that type of animal or that specific animal. Now, you're not required to provide a reasonable accommodation where the animal poses a direct threat that can't be eliminated or reduced to an acceptable level through the actions that the individual takes to maintain control, like keeping it in a secure enclosure. I've never seen an emotional support lion in a community association. I wouldn't be surprised if someone has requested one, but I think this would be the type of thing where, you can see even Siegfried and Roy weren't quite able to keep their tigers under control. That type of animal that, frankly, an emotional support bear is the type of thing where I don't think you'd be able to keep it under sufficient control to accommodate this requirement that you're not causing danger to the other members of the community, the other residents of the community by having the animal. A determination that an assistance animal poses a direct threat of harm must be based on individualized assessment, relying on objective evidence about that specific animal. So I say, I can't imagine an emotional support bear being acceptable, but you need to take a look at that particular animal. If that animal is a bear, but it's an extremely docile bear and it's not being drugged to be made docile, then you know what? It is feasible, although unlikely, that emotional support bear might be something you need to allow. The most important part of all of this is that this has to be an interactive process. You can't just say, well, we got your request and it's respectfully denied. You have to go through this procedure that I've described of making the determination based on information that you either have or that you request from the person making the request for an accommodation before you simply deny the accommodation because, well, we don't have enough information. We don't think that they need it. Well, the bottom line is that might be just good enough to get you in trouble. You can't insist on specific types of evidence if the information provided or known to the association meets the minimum requirements. In other words, if you've got enough information to answer the questions that we went through that were in that kind of breakdown, the yes and no questions, then you can't go further than that. Disclosure of details about the diagnosis can't be required. In other words, again, you're not asking for specificity about a diagnosis or severity. You're just saying, is there a disability? Is it served by this item? And again, that's not self-identification saying, yep, I have a disability. It's, yes, there is evidence that I have a disability, or it is open and obvious that I have a disability. If you refuse, you need to consider alternative accommodations. No, you can't have an emotional support lion, but you can have an emotional support cat. Okay. You can't park in this particular area because it's dangerous to the community, but you can park in your own driveway, or you can park across the street and you can have the other owner, the other resident of the property park across the street so that you can park in the driveway, etc. You're providing alternatives, either that would be an accommodation or even that wouldn't. And if the person doesn't need the accommodation because there is an alternative that will still support and serve the disability, then frankly, from my perspective, this isn't even an issue that should have been raised by the owner. That doesn't mean you tell them, nope, you can do this. You can do it the right way or not at all. No, you have this interactive process. You present alternatives. You try your best to work with the owner before you reject any of these requests. Now, the other thing that I haven't mentioned yet, keep in mind, oh, you know what? I think we're getting into it in the next slide. Let's see. Can't require them to pay a deposit for assistance animal or an extra fee, but you can require them to pay if the animal causes damage to repair that damage. You can't ask them to provide access to medical records or medical providers, which is what I was about to get into, and then realized, wait, no, you can't do that. Or provide detailed or extensive information or documentation of a person's physical or mental impairments. You can't unreasonably delay, which is what I was just about to get into, a response to a reasonable accommodation request. An undue delay in responding may be deemed to be a failure to provide a reasonable accommodation. This is yet another reason that I strongly recommend every community has a policy, and that policy includes, we will get back to you within X amount of time, then you follow the policy. Now, unless that policy says that the time is going to be unreasonable, for example, 45 days to respond to a request to, have an accessible parking spot is probably not a reasonable time frame. But in my opinion, if you put in there that the board is going to meet and decide and discuss this within 20 calendar days or request further information within 20 calendar days, I think that a judge or the Florida Commission on Human Relations or Housing and Urban Development would be hard pressed to say that you didn't comply within a reasonable time frame, or at least respond within a reasonable time frame. Once you've allowed the assistance animal, where can they go? Well, pretty much anywhere that individual can go, except maybe inside the pool. Okay, the association must modify or provide an exception to any no pets rule or policy to permit someone with a disability to live with and use the assistance animal in all areas of the premises where people are allowed to go, unless it would impose an undue financial and administrative burden or would fundamentally alter the nature of the housing provider services. So if you're making major changes to the actual community to accommodate that animal, that's not required. The policies we put together will generally say that the animal is allowed anywhere that the owner is allowed to go. However, they are only allowed to be walked for purposes of using a bathroom in certain areas. And this is why. Rules governing conduct of rules governing conduct of assistance animals. Conditions and restrictions that apply to pets might not be applied to assistance animals. Keep in mind, when we say assistance animal, when we say service animal, these are no longer pets under your policies, under your rules, under your covenants. These are animals. So you might want to broaden your covenants to apply to animals, not just pets, but they are treated differently regardless of what's in your covenants. So given the board's authority to create reasonable rules and regulations, the board has the limited ability to adopt rules and regulations applicable specifically to assistance animals. But it's not clear as to whether it's acceptable to create those rules governing the animal's conduct, such as a rule requiring owners to pick up the animal's waste if they have a disability that wouldn't enable them to do that, or a rule prohibiting the presence of the animal within a pool area. So there may exist issues regarding enforceability of those rules and regulations and their ability to withstand a challenge, because keep in mind, rules and regulations of the association need to be supported in the declaration and be reasonable to be enforceable. There are other requirements we won't go into because that's not the subject today, but just understand those are some of the requirements that we would talk about if the board was asking me to evaluate what restrictions you can place on these assistance animals' behavior. Even if these rules may apply to support animals, they may not apply to service animals. So these are things we say: consult your association's lawyer, consult the attorney on all of these issues, every single request you get. An assistance animal doesn't count toward the number of allowable pets. So if you've got a 2-dog restriction and the request for an assistance animal is substantiated and allowed, the owner could have 3 dogs, which are 2 pets and 1 assistance animal. Just understand, I've seen situations, and frankly, my own neighbor has multiple emotional support chickens. So I'm not thrilled with that, but it's something that apparently the county and the HOA have allowed. And it's something that you need to understand. Just because they've asked for more than 1, we've had situations where the people argued successfully that the pet needed its own pet, and the interaction between the 2 pets is actually what provides the emotional support to the individual. It's not the emotional support directly from the individual pet or individual pets. It's their interaction, and watching that is so heartwarming that this person just, oh, my anxiety goes away. Whether that's accurate or not, I won't comment, but the bottom line is it is something that the board might be obligated to allow. Violations are fairly serious. Plaintiff can establish a claim under three separate theories: intentional discrimination, meaning you knew about this, you did something to me that shouldn't have been done; disparate impact, meaning I am included in a class that is treated differently inadvertently, but as a practical matter; or someone requested a reasonable accommodation or modification and it was denied, or denied by virtue of not responding within a reasonable time. The places that these complaints can be brought, if someone wants to raise a claim of a violation of the Fair Housing Act or the ADA, you can bring it through administrative agencies. The Florida Commission on Human Relations is one. Housing and Urban Development, which is HUD, is another federal one. Or complaints regarding violations of the Palm Beach County or the Orange County or the Orlando City housing ordinances. They get brought to the local institutions, talking about administrative agencies. So there are fair housing agencies or agencies that address fair housing complaints at almost every level. It might be city, it might be county, it might be state, it might be federal, or it might be all of those simultaneously that people choose to file a complaint. It could also be raised in court. The party doesn't have to seek relief from administrative agencies before filing a lawsuit in a state or federal court. Complaint that's been brought to HUD may still be taken to court as long as a conciliation agreement isn't entered. Conciliation is basically like the parties agree to sit down and discuss this and try and resolve it. And an administrative law judge hasn't started a hearing. So keep in mind, this can be brought to court and separately brought into these administrative agencies. And then finally, the division. The division won't hear fair housing claims. The claimant will be instructed to file a complaint with the administrative agency and provide proof of that filing for stay of arbitration. The division is a state entity that deals with arbitration of disputes between associations and owners. They're basically going to say, not my job, go deal with the right people, back off, or at least that's what they're supposed to do. Whether they'll actually do it, case by case basis. And by the way, if they don't do that, then that's what your attorney should be pointing out, that the division has no jurisdiction to decide these issues yet. Apologies. Let me step back here. HUD administrative hearings. So if HUD finds reasonable cause after there is conciliation that's not successful and doesn't result in a settlement, and HUD finds reasonable cause, meaning that there was a valid basis to raise this discrimination claim, the case goes before an administrative law judge within 120 days, or either party can ask for the federal district court to actually hear that. HUD or DOJ decision not to proceed with an FHA matter doesn't mean that they can't still pursue a lawsuit. It just means that the federal government is not going to be the one prosecuting these claims. If the case is heard by the administrative law judge and they determine that a discrimination occurred, there are a couple things the association can be ordered to do. That can be compensation for actual damages, including humiliation, pain, and suffering. Provide injunctive or other equitable relief, meaning making that housing available to the complainant or making the association allow that assistance animal. Pay the federal government a civil penalty to vindicate the public interest. The maximum penalties are $16,000 for a first violation and $65,000 for a third violation within 7 years, and to pay reasonable attorney's fees and costs. Now, something that's not mentioned here, but is extremely important. The association doesn't get its fees and costs back on any of these claims unless you can show that this claim was raised in bad faith, meaning that the owner or the person filing the complaint had absolutely no basis to believe that they had a valid claim. I've never seen a finding of bad faith, meaning even if you win this case, you're out all of your attorney's fees and costs, and I've seen that skyrocket to $50,000 to $100,000 in the past. Okay, so if you can resolve these issues quickly, please, for your own sake and the sake of your association, resolve it however you can if feasible. If it's filed in federal district court within 20 days of HUD issuing a charge that's found reasonable cause, that's when either party gets to decide that the federal district court's going to decide the case. Within 30 days of that election, DOJ is going to file suit and litigate it on behalf of the complainant. meaning that that complainant, the person that filed the complaint, isn't spending their money to fight this. And that's intentional on the part of the federal government to try and ensure that people are treated fairly in the government's opinion. And that people that suffer from disabilities or that are a member of a specific class are treated fairly. Now, when I say fair, just remember, they call this a reasonable accommodation to have a pony in a condo. So don't forget, when I say fair, it's unfair housing regulations is really what it is for the majority of it. Now, there are definitely circumstances where associations get out of line when it comes to this. But the fact that you basically can be shaken down and spend $5,000 to try and draft a response to these types of things, I frankly find absurd, but that's the law as of now. The federal district court can order relief in actual damages, attorney's fees and costs, and punitive damages. So just understand, those punitive damages I've seen, I haven't seen it in these types of cases, but that could be $100,000 to $200,000 or more. We can't even estimate what that dollar figure looks like. Action that can be taken by the complainant. They can either file suit in federal district court within 2 years of an alleged violation, as long as they haven't signed a conciliation agreement and an administrative law judge hasn't begun an administrative hearing, and a court may award actual and punitive damages and attorney's fees and costs. So this is what we're talking about. Don't get in trouble. Get the policy in place. Get it prepared by counsel who knows this area of law, knows community association law and fair housing, and maybe someone that's done a presentation on it or 20. But bottom line, make sure that you're protecting your community because these issues are prevalent. They may not be as prevalent as they were maybe 3 or 4 years ago now that there is criminal penalty associated with fabricating these documents. But the bottom line is it's still something that happens on a daily basis. I'm dealing with 2 of these complaints right now. And I don't think either of my clients did anything wrong in either one. They still have to pay someone. Unfortunately for them, it's me, or fortunately, depending how you look at it. But they still have to pay someone to defend these cases, whether they're baseless or not. And they're not going to recover their attorney's fees and costs that they spend defending these baseless claims. So just be very careful when it comes to these issues. My strong suggestion is not only have this procedure in place, but if there's any question whatsoever as to what that procedure says you should be doing, contact your attorney and get an independent opinion as to how you should be proceeding, whether you should ask for more information or just allow it or just deny it. And it's almost never going to be just deny it. So moving on, we're done with the materials. I know that we have until about 3:15. I'm going to spend just a few minutes on a couple cases. There's going to be some materials we don't get to. We're on slide 50 of 80 right now. They're all materials that pertain to case studies. I don't think they're necessary to go through in detail, but they're just some examples of things that have happened in the past that we've dealt with that might be helpful to the community. If you want to go through those in a little more detail, please feel free to reach out to me. Again, as@kbrlegal.com. Okay, so Hope versus Key Colony 4. This is an actual case from 2007. There was an allegation that the entire board of directors was personally involved in every discriminatory act mentioned in the complaint, and that every member of the board personally and intentionally discriminated against the families. In response, the board filed a motion to dismiss, alleging that their acts were taken on behalf of the association and they couldn't have individual liability per 617.0834 of the Florida statutes, which is the Not-for-Profit Act, which also applies to condos and HOAs. Because that act doesn't provide against willful violations of rights, which is what the complainant alleged, that was not something that was protected, and the case went forward. So the plaintiffs had stated a sufficient claim against the individual directors, and the court denied the motion to dismiss, meaning, for practical purposes, individual directors, as I said earlier, can be sued for these violations and won't be able to just make the case go away just because they were acting in their capacity as directors of a community association. Moving on, assistance animal cases of interest, Hahn versus Shoreline. This is a 2009 case that was affirmed by an appellate court. The Hahns unsuccessfully asked for permission to keep Booster, which was a dog, as a pet. When they made the request, they didn't claim they were physically or psychologically disabled. The year after the request for a pet was denied, they had the same dog certified as a service animal and then claimed for the first time that they were disabled and needed a reasonable accommodation. For their alleged psychological disability, they provided a letter that for a long time before then, they had been abused, kidnapped, robbed, and assaulted by the stepson of a friend. Meaning, all of a sudden, a year later, after the request was denied, they're saying, well, all along, this guy had a problem. He had a disability, and that Booster should have helped. He argued that if Booster was in his condo and an intruder entered, Booster would at least make him aware of the intruder, summon help, and bring him the phone upon command. In other words, it's a trained dog. He provided 2 letters about Booster's resume. In other words, the things that this individual is trained for, and various certification records showing the training occurred. Manager sent a letter asking for more additional information so that the board could consider the request. Han ignored it. On September 13th, 2006, the GM wrote a letter and basically asked again for documentation rather than simply rejecting it, including additional expert evidence under oath of the nature of the impairment, the manner in which it substantially limits one or more major life functions or activities, how the requested pet is necessary to afford an equal opportunity, and if there are any other corrective measures that will permit the use and enjoyment. He again didn't respond. Instead, he filed a complaint with the Florida Commission on Human Relations that found there was cause to believe that the defendants discriminated with him by not providing a reasonable accommodation. He filed his lawsuit alleging the violations of all of these acts, intentional or reckless infliction of emotional distress, and sought an injunction. So there was evidence provided in that lawsuit that he suffered from severe panic attacks and that he was unable to properly cope with anxiety and stress, and that he was particularly vulnerable while residing at his home due to the past occurrences on that particular property. The doctor wrote that he was prescribing a service animal to provide support and help the guy cope with his emotionally crippling disability, and included a brief description of what specific tasks the dog performed, and included giving hugs to calm him after a panic attack. Okay, there was another letter from a chiropractor. Wrote that he was intimately familiar with the Han's history and the functional limitations imposed by that disability, and that he had certain limitations regarding mobility and that a support animal would assist with that disability as well. Court finds that although the association couldn't have known at the time, the record showed that Dr. Evans' entire treatment of Han consisted of 2 recent 1-hour counseling sessions. During the second session, Mr. Han gave Dr. Evans the text or template for the letter he wanted sent. Although Doctor probably made some changes here and there. In other words, this individual said, hey, doctor, here's a 2-hour payment, sign this note. You know nothing about me, sign it anyway. The court finds also that the chiropractor made no attempt to explain what the purported limitations or disability were, and that at the time that the chiropractor signed the letter, he'd only seen Han twice. He examined him once several years earlier in 1999 and once shortly before he signed his letter. For both visits, he only performed examinations. He didn't render any treatment. And he conceded at the deposition that although he signed it, Han wrote that letter too. So the court basically said the board didn't deny the request, but asked plaintiff twice to provide additional information, which the plaintiff refused to do and then filed a complaint. The board didn't outright deny the request. It held a meeting, put the issue on the agenda, and allowed this guy to provide a speech in support. Given the lack of information they had, and plaintiff previously having requested the same dog as a pet, there was no reasonable juror that could conclude that the board knew the guy was handicapped when it made the decision to deny his request. The association didn't improperly act by requesting additional information. Note what's not here. Okay, this guy basically forced 2 doctors to forge notes that didn't know anything about him, and then filed a complaint after ignoring association requests twice. I don't see anything in this opinion that said that the claim was filed in bad faith. It's just, well, the association wins and everyone goes home. So I'm going to skip the rest of this to leave it open for additional Q&A. I know we're at 3:10 and we don't have a ton of time left. Jeff, if you can do your thing, I'm going to take a breath and a couple sips of water and I'll stop the share, but I will skip ahead to the end. Just understand there's a couple more of these case studies in here. And if anyone needs to contact me yet again, The easiest way is by email to as@kbrlegal.com. Jeff, I'll let you do your thing and then we can get into the Q&A. Thank you. So I'm going to try and breeze through. We do have some questions coming in. And as usual, Jeff, just go ahead and cut me off whenever you think it's appropriate based on the time we have available. But I'll try and answer as many of these as I can. Again, if you don't get the answer, I hope that you will save your questions and email me at as@kbrlegal.com because I do want to answer all the questions that we have. All right, so starting with Todd. An owner provides a doctor letter supporting the need for an ESA to help with PTSD. The letter doesn't state the specific task of the animal. What's the process after this? If he calms down the person, is that a valid reason? Is the association allowed to ask for this detailed support? So keep in mind, there is not a specific function that the animal needs to serve. It's just serving the disability. When you have an emotional support animal, that is not a service animal. So when you say specific task, they don't have to be trained as an ESA. Now, presuming you're talking about, we're trying to figure out basically what the function is, you can ask for a doctor's note that's a little more specific. I wouldn't go into too much detail, but it's, there is a general disability that the individual suffers. This is the task that the dog or the animal performs. I don't see a problem as long as you're making sure that you're being as generic as possible in saying we do need a little bit more detail as to the relationship between the disability and the animal. What I would suggest is either have your counsel draft the letter or email that's going to be sent out to this individual, or if that's something that you choose not to do, at a minimum, review the HUD guidance that I've mentioned and that's in the slides today, or not the guidance is in the slides, but it's named in the slides. Take a look at that because it'll probably give you a good idea of how detailed you can be in the questions that the board intends to ask.
Hey, Ellen, let's do, it's 3:15 now. So let's do up to Carol's question, up to the one entered at 2:15. Okay. Anything that comes in after that, we'll have to call it quits because it's running late.
Okay, deal. So Todd, my suggestion, run that by counsel, have counsel draft the email or the letter. But again, if you don't have counsel, you're welcome to contact me and maybe we can work with your association. If you do have counsel, have them do it. And if you frankly just don't want to pay for counsel to do it, at a minimum, please check those HUD guidelines. All right, so moving forward, once permitted, are rules different for ESAs that run afoul of community animal behavior rules? For example, rules against aggression towards other animals or people. So Christopher, that's a good question, and it's one that I vaguely addressed during today's presentation. Essentially, yes, the rules are somewhat different. Basically, if the animal is not a danger to the property or other individuals, you probably can't do much to regulate the behavior. However, you've given rules against aggression towards other animals or people as the example. If that animal has actually threatened, in other words, there's a reasonable fear that that animal is going to actually attack, bite, whatever, scratch someone, those are potential rational bases to go after the individual owner and say you need to either control your animal or get a different emotional support animal. Now, again, that's one that you're going to want to run through counsel so that you're wording it in a way that just the wording itself won't be what gets you in trouble. Are the ESA allowed to be at work with the owner? Generally, yes, but keep in mind, James, that this is not a class about employment law in the context of emotional support animals. That would be a better question for an employment attorney, but generally speaking, yes. I won't give any specifics because frankly, that's not my area of law, but you'll probably be required to allow that emotional support animal in most instances, unless, for example, the individual requesting it happens to be a chef working in a kitchen. That might be a situation where an emotional support animal is not allowed. Cheeky, if bylaws and regulations stated no pets and the resident moved in with a pet, they bark, they poop, how do you handle it? You send a violation letter saying you're in violation. And if their response is no, this is an emotional support animal, then your response is to go through the process that we outlined during today's class or presentation. So you treat that animal as though it's not an emotional support animal or a service animal unless and until the owner actually makes a request for an accommodation. If they haven't requested an accommodation, that's still a pet for now. All right. Let's see. Jane, owner's daughter, has an ESA dog, now wants to buy a puppy as her ESA is aging. Will this puppy automatically be an ESA? Absolutely not. Specific to each animal. So the fact that they are allowed to have a dog doesn't mean they can have two dogs just because one is aging, and doesn't mean that the new dog is going to be allowed as an ESA unless it's been treated as an ESA. Generally speaking, it's specific to the individual animal. And Carol, I think Jeff said yours is last. What if other owners are adversely affected by the animal? Example, allergy to the animal. That's an issue that needs to be addressed by your counsel on a case-by-case basis. I've actually come across this situation before, and my response was that is adversely affecting others, and it is causing the individual who is being adversely affected to no longer be able to use their property to the extent that everyone else is. And as a result, it's a problematic animal, and consider trying to have it removed. So I don't know if we've still got any time left, Jeff, for me to cover any more, but
I'm leaving that to you because I know you have appointments after this. So if you want to get to as many as you can, that's entirely up to you. I'm good.
yeah, I like to try and get through as many as I can. It
You
looks
got it.
like I already handled some of this, but Lois asks, in our condo rules, if we want to limit pets by size, weight, breed, should it state something about those restrictions don't pertain to ESAs? No, this is an accommodation of your rules. So you're going to have the rules be whatever you want them to be. And when someone says, I have the need for an emotional support animal, you evaluate it differently. So no, those rules don't need to specify anything about ESAs. It's just a policy that I would suggest you have that determines how you treat those requests. Is there an actual certification or documentation to be a trainer of service dogs? There are qualifications, and I'll be completely candid. I have absolutely no idea, Lisa, what those look like or what they are.
Something you can go to your local vet and probably get the answers at your local veterinary clinic.
Sounds about right. Andrea, when an emotional support animal is in our pool area, the owner allows them to sit on the concrete, sip water from a bowl, and sit on our lounge chairs. We're reluctant to request they removed due to the response of the owner, which is usually vulgar. I think that it's more appropriate to deal with the conduct of the owner than the animal in that circumstance, because the vulgar response is inappropriate and unacceptable in my opinion. If their response is, I'm not going to move because I'm allowed to do this, that's an appropriate response. If their response is, go F yourself because I have a right to do whatever I want, that's not an acceptable response. And that's something that the board should consider enforcing in and of itself. But bottom line, yes, generally speaking, the emotional support animal is probably allowed to be in the pool area, but not in the pool. Todd, what about a constant barking ESA or service animal? Similar to a dog that is going to bite people, that is still a nuisance, whether it's a service animal or an emotional support animal or not. And Denise, will there ever be a day when we'll be able to weed out the pet from a true support animal? Probably when it's worse than a 30-day sentence of having to do volunteer work as a penalty for fabricating this documentation is the day that we'll see that. Now, keep in mind, for 20, 30 years, there was no penalty whatsoever. That penalty just came around a few years ago. So maybe it'll gradually get more and more severe, but I hate to say it, probably not. And then finally, John is the last one. Can an HOA ask for a yearly recertification for a support animal? Most likely, yes. I don't see anything specifically wrong with it. There's nothing that prohibits it. But if you know that the conditions of that animal and the individual haven't changed, then that might be considered a violation of the Fair Housing Act. And with that, I am not taking new questions. I wanted to make sure to get through. When I say get rid of, I meant on the list, but I wanted to
Get it
get
done. You want to get it done.
past. Right. So fortunately, it only took another couple minutes. I really appreciate everyone being here today. I know that this was a little bit of a blitz, which tends to happen in these types of classes, but I hope you all got a lot out of it. Again, I welcome anyone that has any questions whatsoever regarding community associations. Reach out whenever you want. I'm happy to communicate and discuss these issues. And if our firm can help your community with these issues or anything else, I'd obviously like to hear from you about that as well. Jeff, thank you, of course, for your help, especially given your coughing fits that I've seen over the last few weeks. So truly thank you, and thank everyone that attended today. And Jeff, I'll turn it over to you for the rest.
Thank you, sir. I know you have to head out to meetings and appointments, so thanks once again. Cough is much better. Thanks for the words. It's that don't ignore it, folks. This last strain of COVID, which I had positive a couple of weeks ago, it's legit. It's this one got me. The first two times didn't get me, but this one got me pretty severely. So mind your health, everybody. Alan, take care. Thanks, buddy. I will chat with you soon.